Okay, call this meeting to order. Cool. So stand for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, now do a roll call.
Okay. Commissioner Morale? Here. Commissioner Davis? Vice Chair Anderson? Here. Chair Gonzalez?
Here.
And we'll reflect for the record that Commissioner Zunino is absent.
Okay, it is now time for the public communications, which is the time for the public's opportunity to speak on any topic not listed on the agenda. We have a big crowd today. Comments shall be limited to 3 minutes. Do we have anyone in the public who wants to speak today?
And we have no one on Zoom, Chair.
Okay, great. And so with that, we can move on to regular new business. And the first one is the passing the minutes from May. So,
The minutes are presented for your approval.
Seconded.
great.
I'm sorry, who seconded? Sorry, thank you. Sometimes I can't get that far. All right, we just need a couple more people to vote. Ms. Morelli? Yeah. Oh, I'm sorry, the minutes will reflect that it's approved. I forgot to update that button, sorry. But the minutes carry, thank you.
Okay. Next, we have Mr. Barzell to present on the gun violence restraining order presentation.
All right, good afternoon, Commissioners. So today I'm going to be talking about the city's gun violence restraining order program as it's recently been developed. So the city of South Lake Tahoe, the city of Placerville, and El Dorado County participated in a training a few months back on some of the new legal developments in this area and how some other places have implemented this type of a program. So after that, we have started to do it ourselves here. So I'm going to go through the different types of gun violence restraining orders and the process for seeking one from a court. So background on the restraining order itself. So a GVRO is a civil restraining order in writing signed by a court prohibiting a person from having guns or ammunition, essentially. There are 3 types of GVROs. So there is a temporary emergency firearm protective order. There's also an EPO. A temporary gun violence restraining order. This is a TGVRO. And the third is a permanent gun violence restraining order, or a PGVRO. So the EPO is a temporary emergency restraining order requested by a law enforcement agency to prevent a subject's access to firearms and ammunition when the subject poses an immediate and present danger of causing personal injury to themselves or another. The TGVRO, this is a 21-day ex parte restraining order requested by a law enforcement agency to prevent a person's access to guns and ammunition until there's a hearing to obtain a permanent order. And then the third type is a PGVRO. This is a court order enjoining a subject from having firearms or ammunition for a period of 1 to 5 years, and this would typically be after notice and a hearing. All right, so the process for seeking a TGVRO, so this is the temporary gun violence restraining order. So the law enforcement agency would file a petition requesting that the court issue an ex parte TGVRO. So to do so, the court can issue it if the petition shows 2 things. First, the subject of the petition poses a significant danger in the near future of causing personal injury to the subject of the petition, meaning the person with the guns, or to another. by having in their control a firearm or ammunition. Second requirement is that the order is necessary to prevent personal injury to the subject of the petition or another because less restrictive alternatives have been tried and found ineffective, or it's not appropriate for the circumstances. So if those two requirements are met, the court can issue the TGVRO. And typically it would be issued the same day it's requested. So if the court does issue this TGVRO, it would be an order prohibiting the subject of the petition from having firearms or ammo, but it would only last for 21 days. So the gist of it is this is a temporary stopgap measure until you can have a full hearing, noticed hearing for a permanent order. So that's the first type. Second type is a PGVRO, so this is a permanent order. With this type of an order, the city would request that a court, after notice and a hearing, issue the order enjoining the subject of the petition from having firearm or ammo for a period of 1 to 5 years. So the person or the agency filing the application could argue for why a longer order is necessary, meaning the 5-year limit as opposed to a smaller one. But it would depend on the circumstances, and the court would have discretion within that range. So at the hearing, in order to have a court enter this order, the petitioner would have to show the following. First, the subject of the petition poses a significant danger of causing personal injury to themselves or another by having firearms or ammunition. And then the second is that the order is necessary to prevent personal injury to the subject of the petition or another because less restrictive alternatives don't work, essentially. There's a clear and convincing standard in order for the court to issue it, and if the standard's met, they'll issue that order, and it can be, again, between 1 and 5 years. If, at that point, there is not clear and convincing evidence shown to the court, they'll dissolve any temporary order in place at that time. If an order is entered, the person that the order relates to can apply periodically to have the termination of that order sought. So they can seek to have it dissolved if they can show it's no longer needed. And then the third order is an EPO. So this is, again, a temporary emergency firearm protective order. This is a tool for law enforcement to use when the court's closed or it's after hours. Essentially, the agency petitioning for the order can phone the judge and say that we need this order, and they could grant it over the phone and then memorialize it later with a written order. To do so, in order to seek in this way, there has to be a particularly strong showing of a threat. It's the standard is immediate and present danger of causing personal injury to himself, herself, or another by having firearms or ammo. So if you can show that, and also show that less restrictive alternatives won't work in this instance, then the judicial officer can issue the EPO orally based on the statements of a law enforcement officer that would give evidence to meet these standards. This one similarly expires 21 days from the issuance of the order. So again, this would be another stopgap measure to reach the hearing for a permanent gun violence restraining order. And with that concludes my presentation, and I'll take any questions you guys have.
How many of these have we requested in this as a city?
Well, since the city attorney's office has been involved, we've requested one, and the police department has requested in the past before we formalize the process. I don't have the previous statistics handy, though.
Do we have any clarity on what the enforcement mechanisms are for these restraining orders and violations of them?
Well, if someone is found to be in possession of a gun when there's an order in place, then you could apply to the court to So basically, if they're arrested and they have guns on them, that would be another basis to charge them with violation of the court order, is my understanding.
One of the things that you noted in one of the, as one of the requirements is that this has to be necessary to prevent injury if there's less restrictive, or if less restrictive methods haven't worked. Can you explain what those less restrictive methods are?
Well, for example, if it was someone that was underage and their parents had the guns, and previously the parents were told they needed to lock up the guns, but they didn't do it, then it might give a stronger basis to now remove the guns from the residence, things of that nature.
What's the difference between the city attorney's office requesting it and the police department?
Well, it's more just helping them with the legal process.
Okay.
So we're working in close conjunction with the police department. Basically, the officers would assist in preparing the petition. We would give it a legal review, and they would act as witnesses if needed at the court hearing. So we would attend the hearing with them.
So like you said earlier, one of the orders, there's a mechanism, holidays, weekends, you have a process available to get one when the court's closed.
Correct. And in some instances, the officers might be contacting the court directly. I believe they've done so in the past. But if needed, the city attorney's office would jump in as well and could be in touch with the court to seek that.
So is the police department requesting on behalf of a citizen, or is?
No. So they're requesting on behalf of the city. So if it comes to our attention that there's someone with guns that is a danger to themselves or others and meets these standards, law enforcement can seek it not on behalf of someone. We would be doing it in these circumstances on behalf of the law enforcement agency.
So I'm thinking in cases like DV, if is there a mechanism for citizens to?
Well, for
you know what I'm
it's
asking.
outside the scope of like my typical practice with the DV. That's more a criminal area.
Okay.
However, my understanding is that that would be a separate thing. So if there was a DV victim, they typically could seek a restraining order that I believe could include a gun-related provision as well in the order. But again, that's just my general understanding. I haven't researched it specifically.
Stevenson has opinions.
I can help with the answer on that. In a domestic violence situation, there's already a system in place for emergency protective orders related to that incident, and it does involve firearms as well.
And then potentially, like, if there's reoccurring cases, one would pursue a more temporary restraining,
It's
or a
ba-
more permanent restraining order?
It's almost an identical process he described.
Okay.
It just already exists for those
Nice.
situations.
Cool.
I had one last question. The permanent here is 1 to 5 years, which is not so permanent. Is there a renewable, like a renew clause or ability to renew after that 5-year term if possible?
It's a good question. I don't know off the top of my head. What I would imagine is if there was a continuing threat, we would go back to the court and seek an additional, order. However, it would be a new process.
And then these are definitely sitting more in the civil violations as opposed to the criminal violations. Okay. So
Correct. It's a civil order. It's actually, it falls under a penal code provision that sets this whole process up. However, it is a civil order.
Are there any other questions? Do we have questions from the Zoom?
It would be public, we can open it up for public comment if you'd like.
If the commission is done asking questions, then we could open it to public comment. But the process would be they would be asking or making their comments just to the commission generally as opposed to me specifically. And then the
Right.
commission can ask me questions if you have any follow-ups.
Thank you.
You're welcome.
It's been a rough couple of days for me. Thank you for the presentation. We will open it up to public comment now.
We have no members participating via Zoom.
All right, I think that puts you up, Chief, for our annual Police Advisory Commission report.
Thank you very much. Again, this is the Police Advisory Commission Annual Report, not to be confused with the Police Department Annual Report. This report is required per the commission resolution from the city, that every commission in the city, not just the Police Advisory Commission, has to turn in a written annual report to City Council every year. I did this last year. If you remember, the timing didn't work where I presented it to you folks first. And it is just a summary of what was basically a summary of the topics covered during the previous year. And with that, I don't really have much more to say about it than that, other than it will be going to City Council on the 21st, I think, is when all the commission reports are going, or in the month of November, I believe.
Can I request that my name be spelled correctly, please?
Oh my God, did I seriously do that? Yes. In the first paragraph you're talking about?
Yeah, under background.
Yep,
It's-
sorry, I apologize for that.
That's okay.
It got spelled wrong once somewhere, so it sticks.
That's also how Word auto-corrects it. Any commissioners have any questions on this report? Okay, thank you. Chief, and I guess we'll open it up to public comment. Right,
Still no members on Zoom.
great. So now we have Lieutenant Jeff to come talk to us about SB2, Peace Officers, Certification, Civil Rights.
Yeah, our plan was I was going to queue it up real quick, and
Okay.
then I'll introduce him. So he is going to be doing the presentation. Thank you again. This is going to be for a more in-depth look in Senate Bill number 2. It was briefly mentioned, I believe, last year or the year before. This bill includes a lot of new laws that includes, that covers a lot of the areas in regards to transparency, accountability, public trust, oversight, all those kinds of things. It added new requirements to peace officer hiring process. Back when we mentioned that this bill had gotten passed, nothing had been figured out how it was going to work. I wanted the commission and the public to know that that's since been figured out, and it is a process that is up and running, and we are participating in. So without further ado, Lieutenant Jeff Robertson, and thanks to him as well, because for the last 2 years, he has spent countless hours getting trained on this stuff, going to the seminars, things like that. It was a heavy lift. There's a lot of information in it, so I appreciate his work on it.
Good afternoon. Senate Bill 2 kind of came about because California was one of the few states that didn't have a disqualification process for police officers. Police officers could basically be involved in a internal affairs investigation of serious misconduct, leave their agency and land at another agency, be hired by the other agency, and because of personnel requirements, the other IA at the original agency may never be discovered. So SB2 was put into place so that those things would come to light. There would be a central repository for some of those investigations into serious misconduct. And so in the process of developing that, SB2 empowered Post to have an enforcement component, to have an investigation component, and have this repository for the information that would come out of an agency if an officer left. So if an officer were to have an investigation against them at the original agency and they would resign prior to the conclusion of that investigation never technically is concluded. It doesn't go in their personnel file. And so this was kind of to rectify all those things that existed that were workarounds. And California also became a participant in a decertification process, as well as listing officers that had been decertified on the national decertification list. So that's kind of the background of SB2. So SB2 had a lot of accountability changes in how officers were hired, how their serious misconduct was treated. So let's start with the hiring process. Do I have control of this? Yes. Awesome. Okay, so SB2 changed the hiring criteria for peace officers, added some disqualifiers for the initial hire. So, like a dishonorable discharge from the military, if you have a felony that was set aside, if you had a crime of dishonesty, stuff like that, those would be automatic disqualifiers, and they added an age requirement to it as well. SB2 gave, like I said, post-ownership of the peace officer certification. It used to be that the officer was the owner of their post certificate. Now the state owns it and has the power to take action against it. And SB2 also established that the suspension revocation process, which is pretty elaborate, once the serious misconduct allegation lands, the agency does the internal affairs investigation, and then it's reported to the state. In the hiring criteria, they really went after a bias assessment framework in that. And several components that were included there were background investigations. They wanted to have the background investigators, through their interviews with the candidate, through their friends, through their neighbors, through their family, determine if there was any implicit or expressed bias there. They also added a caveat that their social media had to be reviewed for bias as well. Another component was adding criteria for their psychological screening that had specifically addressed any implicit or expressed bias. So just to give an example of what they added to the requirements for us to verify qualification for police officer appointment, we end up doing a query to the state, like I was talking about the central repository. We end up doing a query to the state to see if that officer's name lands in the central repository of serious misconduct, the social media checks, and then we have to confirm and affirm that because of the requirements in government code, that the officer is not precluded from being employed as a police officer. So the next request is that portal where that's the portal that we go to, that is basically we give the state the name, and they spit out whether they've been subject of an investigation in another agency. And again, so with post having the ownership of the certificate, they have the authority to suspend or revoke a police officer's post certificate. If an action, I'll get into the timing in a minute, but if an action comes to light that that post needs to do an emergency suspension of a police officer's post certificate and basically take away their peace officer powers immediately, they have that authority. Their revocation is basically the result of a process, a several-step process that starts with the allegation.
Can I ask one quick question? It's me. Can you explain what a post certificate is, though? Because
Sure.
I know Post does their trainings,
Okay.
but I don't know what
All
the
right.
certificate is.
Yes, so POST stands for the Police Officer Standard and Training, and it's a California agency, statewide agency that oversees training, certification, minimum qualifications, some mandates. So like say, let's use an example of a SWAT team. No, that's not a good example. The reason I say that it's not a good example is because there are recommendations for minimum, what's the word I'm looking for? Minimum training qualifications is a recommendation, but there's not a standard there. That's why it's not a good example. But so as a police officer, you have to have 24 hours of continuing education every 2 years. Post oversees that you maintain that continuing professional training. They keep up with all that stuff. They come in, they review our background packets on our police officers to make sure that we've, done the due diligence in getting into their background to find out who they really are at their heart, and making sure that we have good qualified people in that job. So POST is kind of the governing body of giving you license to exercise police powers.
What's a certificate? What's a post certificate?
So there are several post certificates. There are about 5 for police officers. So the first one is a basic post certificate. As a police officer, I get hired, I go to the police academy, I come out of the police academy, and now I have to, as an agency, I attest to that person is qualified to be a police officer. They go through training, they go through probation. Once they complete probation, they get their basic post certificate. And then depending on some other educational and training criteria, it may take somewhere up to 6 years. You can get an intermediate post certificate, and somewhere between 9 and 12 years, depending on, again, officer's education, they can get an advanced post certificate. And then there's supervisory certificates, management certificates, and executive certificates. We also have post certificates for dispatchers. We also have post certificates for dispatch supervisors, for record supervisors. So there's quite a few post certificates. So, but I'm sorry for glazing over that. For the guys that don't know what, I just ramble off with the acronyms. Meanwhile, where was I? Anyway, so they have the power to revoke and suspend the officer's certificate that gives them the power to exercise their duties. So in SB2, there was several disqualifying misconducts that were enumerated. These are applicable in the pre-hire stage, in addition to the other disqualifiers in the pre-hire stage. Those include certain misdemeanors and crimes that occur in other places that would be a felony in California. So say I'm in Tennessee and I have a relationship with a younger girl. I don't know if the age of consent there is 14 or 16, but I come to California and now it's 18. That could be a disqualifier. So additional disqualifiers include, like I said, UCMJ violations, Uniform Code of Military Justice violations. If you had a previously revoked or surrendered certification, either from our state or from another state, or if you appear on the National Decertification Index for conduct in another location that would be considered serious misconduct in California. So we have a reporting requirement to post about the serious misconduct, and I'll get to that list in a minute. So the reporting requirement is that at allegation, we have 10 days to notify the state of the allegation. And if let's say it's serious misconduct, officer resigns prior to us getting an internal affairs investigation started, we still have to make notification to the state, basically so they can have that central repository so he or she doesn't land somewhere else in the state. As far as the suspension and revocation process, like I said, they can take an emergency suspension of your post certificate, but the process of the revocation requires quite a bit of documentation to post. We'll do our internal affairs investigation, and then we will provide them a summary, and then we'll provide a copy of our report, a copy of our evidence, a copy of the complaint, kind of the whole package that we drew our conclusion from, to make sure that the state reviews it and they come to the same conclusion. If they don't, they will let us know. And so the post review, when SB2 was first announced, it sounded like the review for the revocation of your post certificate was going to be very kind of superficial. And like the chief said, I've been to a few of the trainings. The review process for revocation is very robust, and the people at post that are doing the reviews and the decertifications, they know the difference between a disciplinary issue and a disqualification issue. So just because an allegation happens and it goes to the state doesn't mean that every officer is going to have their ticket pulled and they're never going to be able to be a cop again, or that we're going to run out of cops because all the cops are decertified. Now kind of the meat of the issue. So here's serious misconduct defined. There's 9 criteria: dishonesty in an investigation, a prosecution, or other misconduct, an abuse of power with witness intimidation, false confessions or arrests, physical abuse, excess or unreasonable use of force, and sexual assault. And let me deviate on that one for a second, because sexual assault as defined here is different than sexual assault as defined in the criminal code. So sexual assault, according to this section, is the commission or attempted initiation of a sexual act with a member of the public by means of force, threat, coercion, extortion, offer of leniency, or other official favor, or under the color of authority. And for the purpose of this definition, the propositioning for or commission of a sexual act while on duty is considered a sexual assault. So it can be it doesn't have to be the act. It can be the request for the act, and that qualifies as sexual assault in this context for serious misconduct. So can you continue on? We have demonstrating bias that violates law, policy, or is inconsistent with peace officer duties, egregious or repeated law violations. If the officer was a participant in a law enforcement gang if an officer was uncooperative in a misconduct investigation, or if the officer failed to intercede in a use of force. Those are the serious misconducts. So in the reporting process to the state that has to happen within 10 days of the allegation, there's two components to that. There's the initial notification in the Mark 43 system, where, let's say, a serious misconduct issue happens, and all I know is the complainant, the date, the time, the location, and we haven't launched an internal affairs investigation. I still make notification to the state that this has happened, and this investigation has launched. We give them an idea of what the complaint is. So if it's, use of force, it's racial bias, or it's dishonesty, we'll give them an idea what the entry is about, date, time, and location. Then after our internal affairs investigation lands, we'll add to that the summary of the investigation and the documents of the investigation, and send that off as a complete package for their review. And then one of the most significant things that changed is that usually the citizen complaint had to come through the agency. You'd have to walk, a lot of agencies you got to walk through the front door. You got to fill it out in person, all these other things, where now Post has made it where a citizen can complain directly to Post, and then Post can launch an investigation. They'll make notification to the agency that somebody's complained against the officer, and then it'll start from that end rather than from our end or from the front lobby end. So as far as how the police department is participating, we've done continuous training for our background investigators to make sure that the new criteria. You want me to grab some water? Oh, okay. Okay. So we've done continuous training for our background investigators that include, how to kind of ferret out the biggest component was that racial bias, implicit or expressed. And then we've confirmed that our post psychiatrist, she is compliant with the requirements of SB2. And we've also adopted an affirmative process that we're actively participating in the Mark 43 system, as well as the rest of the SB2 components for hiring, separation, et cetera. The other component that I wanted to add, and I saw this on the agenda, is that it talked about civil action. So there was a component to SB2 that talked about eliminating certain limitations on civil claims against officers in the agency for particular behaviors. And that is far beyond my scope. And with that, I will conclude.
What other states have this? You mentioned other states? You don't have to name all the states,
Right.
roughly half of the states? Or?
I think the last time I looked, which was probably a year and a half ago, was 37.
Okay,
I know
so
that
most
Georgia has
states.
one. That's the only one I know for sure.
Yeah. This is just I'm curious question. How do you guys test for implicit bias? That feels like a hard thing to test for.
It's not a test. It's basically you have to ferret that out in your background investigation. It's, what do the friends say? What does the family say? What does the neighbors say? What does your social media say?
Got it. Okay.
Yeah.
That makes sense.
Yeah, it is very difficult to get in somebody's head and find out what their true beliefs are.
Yeah. Or even just ones they don't know, right? Implicit bias
Right.
is you don't know you have
You
your
don't.
own. Yeah.
Yep.
Are there any other questions from the commission?
Thank you, sir.
All right, I guess we can go ahead and open it up to public comment. Seeing no one in the room and no one on Zoom, we can close public comment. And the chair just stepped outside to cough, and so we can go ahead and, is it okay if we continue with the meeting?
I think it's okay.
Okay, all right, so next up on the agenda are staff reports and updates. Are there any reports from staff?
I don't have any.
No reports from me today.
I just wanted to mention one thing, that we do have a solicitation for seats on this commission, which are expiring in February. We'll have 2 seats that are open for Commissioner Zunino and Commissioner Anderson. So we have flown that solicitation. If anyone is interested, the application is available in my office or on the city's website, and details are on the notice of solicitation when those are due. City Council will be making those appointments in February. And that's all I have. And next up, we can go to commissioner reports and updates.
Do we have any updates or anything we want to agendize for our next meeting? Okay, it looks like for right now, we don't have any. So with that, I think we can adjourn.
All right, thanks, everyone.
Thank you.